time. So what the FDCPA does, it's the Fair Debt Collection Practices Act, and it stops collection companies from using abusive, unfair, or deceptive practices to collect your debts. What is the most common violation of the FDCPA? It's either incessive harassment, and I also do, the biggest one I do in my office is called an E8, like I was telling you. If you send a validation verification letter to a collection agency and they get it, they have to respond back to you, and they also have to mark the account disputed. And that is the biggest thing I get on my FDCPA violations. I audited 10 files about 3 weeks ago, and I had 6 clients that had violations, and 2 of those clients had 2 violations. So out of 10 audits, I had 8 violations. And let me explain to you what that means when you can catch someone on a violation. There's money a lot of times for your client. It's not only the dissolution of the debt, it's the removal of the account. And a lot of times it's money in your client's pocket. So there is also something I call the CC violation. It's when you send a do not contact me letter to a collection agency. And in the state of California, it's also the creditors that are involved in something called the Rosenthal Act. So if you send a collection agency a letter saying do not contact me, and they violate that and they contact you, communicate with you, then that's a violation as well. And both of those violations normally have $1,000 payout to your client. And in my office, we take a % of our client's settlement. It's part of what we do. And so we are really just looking for violations. There's a new thing that I started putting in place in my office. It's called, I call it an inconvenience statement. It's inconvenient for you to contact me any method other than XYZ during these times. And if they violate you, let's say you tell them that they can only email you from 12 to 5, Monday through Friday, and they send you a statement in the mail, they send you a text, then that's a violation. And those are what you're going to use to actually help get those accounts removed. So it has to have a balance. And I don't do it over $5,000, Stephanie. There are too many lawsuits that come from this type of thing. And for me personally, in my office, I have different things in place to help my clients if they're getting sued. One of them is now arbitration. And I am doing some arbitration work behind the scenes when my clients are getting sued. If they contact your client, if they don't mark the account in dispute, if they contact your client outside the parameters that you set in place, those are all violations, and those are all violations that our attorneys want. So for you on your end of this Zoom, my suggestion would be get in touch with an attorney, a consumer attorney. I happen to have several of them because different ones take different violations. And I also owned what's called an attorney brokerage, to where I actually was buying files from the CROs and sending them over to the attorneys. And that's how I actually got into relationships with so many of these attorneys. So everything I do in my office is truly, I feel, legal with my letters and my processing of these documents. You have to use the annual credit report at the end to capture the violation. And then once you have the letter and you have the certified receipt, because you have to be able to prove they got it, and you have the annual credit report, that makes a very good file for an attorney. Then your client goes into a consent to communicate, and I send them over to the attorney of choice, or the attorneys that are able to take the file. I don't quote laws. None of this right here is something I quote in any of my letters. I am not an attorney. I'm working on behalf of a consumer, and most consumers are not going to know what these laws are. So I personally do not write the laws in the letter. And my attorneys need just very generic, basic, this is what's going on with the account, this is what happened, I feel like you're violating my rights, and I'd like to do something about it. So it's not necessarily about having to understand so many of these rules and these laws. It's just about making sure you're processing your documents correctly. And so I send out a validation letter with the inconvenience letter is part of it. Obviously, I do my PBI and my inquiries because those are valid as well. The second and third month are one letter to the credit bureau, certified mail. The first letter simply says, you didn't do what I asked you to do. And the second letter simply says, I sent you a letter last month and you still didn't do what I asked you to do. And by the fourth month, I'm sending any creditor or collector that sits on that credit report, I'm sending them a letter. Everything leaves my office certified mail. I need to track postage. I spent $29,000 plus in 2022 on postage for my office. I actually also outsource as part of pre-litigation outsourcing. And so I make sure that my CROs are set up the same exact way I set my files up. Because in the end, if you have 8 violations in a month and you get $500 from each of those violations, you've just simply increased your revenue without having to do anything that you shouldn't be doing anyways. So that's where a lot of this comes in. Most attorneys don't buy files from CROs. It's against the law. And some attorneys out there will do a marketing fee. Some will say that you're a paralegal working in their office, so they can pay you that way. But the majority of attorneys that I work with won't take files that way. It's too risky for them. It puts them at a liability if they do. So honestly, make sure you write your letter. I just am looking for validation. I'm looking for verification. Please send me these documents and don't contact me anytime other than, and this is the correspondence method. So if you really do this the right way, you can be making more on violations than you make on the actual credit repair. And I think that's where the idea of increased revenue comes in, is that we have a second stream of income coming in. Some of you like the secured credit cards or the card brokerings. I happen to like my files being set up the correct way so I can capture the violations. I didn't always do credit repair this way. What happened is COVID hit. And I've always had such great success with my files, my clients. I do not market. I don't do anything other than maybe post a few things on Facebook from time to time, but I don't have any paid ads. I don't run ads anywhere. I really just I've never been that person. I'm not a marketer. So I have always just been referred by mortgage companies, banks, the car dealerships, and the realtors. And that's where my business comes from. I really have set such a precedence in, and I'm in the Boise, Idaho area, and Boise, Idaho was the fastest growing city last year. So I have a wide, huge network of people that refer to me and previous clients. So I don't do the marketing the same way that everybody else does. So I had to, when COVID hit, I had to change my process because the creditors, the collectors, and the credit bureaus no longer had the parameters of the 30-day rule. And I started having my clients call me and say, hey, Shar, I didn't get my paperwork this month. Hey, Shar, it's been 2 or 3 months since I've gotten my paperwork. What's going on? Are you really, truly working on my file? Like, what's happening to our country? And now my credit's not getting repaired after I'm, paying for this. And so I learned what's called pre-litigation credit repair. And that's where everything I do comes into place. So I had to make sure that even my outsourcing clients and my personal clients had proof of the work I was doing for them. So I started doing the certified mail. And then I got contacted by a good friend of mine. Now she's a good friend. I didn't really know her back then. And she said, let's start a business. And so we did. and she's very, very intelligent and knows laws and the way this works. I have had her run circles around attorneys by her saying, nope, that's not right. Nope, that's not right. Nope, this is right. So I learned a lot from her. And then through her and our business, we just communicated and connected with a lot of attorneys across the United States. So when I really tell you that these violations are a true fact, they are 100%. And so my suggestion is to find an attorney that will take your files and not to sell your file to the attorney's office, but to help your client, because they go to bat for your client. These violations do not go to court. Very seldom have I heard of anything like this going to court. In fact, I can't even remember if I've heard anything. It's normally a demand letter, and it's normally the collection agency's attorney communicating back with your attorney, and they just get it resolved. And a lot of times these can be resolved in about a 2-month time frame. I've seen it as early as a 30-day time frame. Heck, I think I have a CRO that had it done in 2 weeks on time. So setting your files up differently and understanding what you're doing, not just throwing stuff on the wall and hoping it sticks anymore, because, hey, I know that's what a lot of CROs are out there doing, generating letters after letter after letter after letter, hoping something sticks and hoping that they just get tired of hearing from you. They don't remove an account because they get tired of hearing from you. So I do not charge my client any more than 6 months of credit repair. I'm very strict on that. I do a lot of pro bono work in the community. I work with the drug courts. I work with the homeless and domestic violence centers, and I do all pro bono work. And the extra revenue I get from cases from my client actually helps me pay for that, because again, I still have that certified mail and I still have my time, my payroll, I still have all of that. So yeah, you become the client's hero. You really do. So there's some more slides that are on here. If any of you would like this to be sent to you, you can certainly message me. I mentor pre-litigation credit repair. I charge by the hour.
Hey, Shar, you can go ahead and go through everything. I know we're at your time already, but I think this is like important. If you want to just like go through all the slides, I can do FCRA like next week or the week after.
Okay.
You know what I mean?
Okay.
Like, is everybody good with that? Because I'm finding this fascinating, to be honest. I love hearing how other people are doing credit repair. And I think Shar has a really unique way of how she does it. Like I do it differently too. But I'm thoroughly enjoying this. So I would like for you to continue if you could.
Okay.
And I have questions
Absolutely.
when you're done. So I just feel like we're gonna go all the way to 6 o'clock. There's no way we're not going to
Okay.
6 with this. So please just continue with
Okay. It's not just what's needed for the qualified refusal to pay from the original creditor, or it's not just the qualified failure to mark and dispute. This is what every attorney pretty much needs. They need the original letter. They need a copy of the communication or lack of communication, proof of the delivery. So I send everything certified mail, and my attorneys expect me to send them proof it was delivered, not just a tracking number, because it's not fair to make them do extra work on my behalf. So I actually print out the proof of delivery, the updated annual credit report, and the consent to communicate. Every attorney that works with a consumer around, an attorney cannot contact a consumer. I don't know if any of you understand or know that. It's misleading. So you have to have a consent to communicate signed by your client that goes to the attorneys. Most attorneys want that. So again, it removes the account, it dissolves the debt, it gives money into the consumer's pocket, and most of these violations are $1,000. You have a $519 phone bill that went to collections, and you not only get it removed and the debt dissolved, but you get $1,000 in your pocket. That's pretty good. And again, I do not send anything out for my clients with a balance over $5,000. I feel it's unfair for me to put them in regular court and not small claims court, and anything up to $5,000 is usually small claims. And then when the client goes to court, not that I give my client legal advice, but I know enough about how this works that I can offer them some suggestions on what to do when they do go into court. I pitch the legal plan from one of my attorneys when I feel it's necessary. Like, you have 10 collection accounts on your credit, you're going to get sued. It's just a matter of time. So I put them in position with that. And I give them all the tools that I know on what to do in a situation like this, because I've seen it for so many years. If you don't show up, you get an automatic default. And if you show up and force them to prove in court the debt, you're not saying it's not yours, you're not recognizing it. And how can you recognize it? When it's all reported incorrectly on all three bureaus. That's why we challenged it in the first place. I also don't believe necessarily that sending letters out to collection agencies will automatically result in a lawsuit, because I've had conversations with collection agency attorneys who have said, if we're going to sue you, we're going to sue you. It's just honestly a matter of time. Your number is where it's at. They do public searches on consumers. Eventually, the file comes up for review. And if they feel like you're in a position to pay the debt back because they found out you owned a home and they found out that you drive a new car and you pay $519 a month for that car payment, because they have access to your credit report at this point. That's why when you look at credit reports, you can see a lot of monthly Midland. It's because they're looking for something. They're looking to see if you have other assets that we can use to pay the debt that you owe them. And at the end of the day, most of this debt is 100% acquired by your client, 100%. And when you walk into my office, I let you know I'm not an attorney and I'm not a lawyer, and these things can happen. So be prepared if you want to go through this process, that first of all, it takes some time. And then second of all, it could bring up a lawsuit quicker. Not bring up a lawsuit necessarily, but bring up a lawsuit quicker. Okay. What to review when writing a refusal to pay. Avoid using the word dispute. Using the word dispute in your letter opens up the debt collector to respond, because if they don't know what you're truly asking for, don't contact me or prove I owe this debt. It's a contradiction in your letter, and they have every right to send you a statement or proof that this is your account. So watch what you use. Avoid threatening the debt collector. Nothing you put in that letter is going to scare a debt collector. They're bigger than we are. Yeah. They're bigger. Yep. So don't threaten them. Don't put abusive language in the letter. Avoid opening the door for communications. Using words like alleged, unknown, unclear, supposed, so-called, claimed, professed. Just don't open the door that gives them any out to send you what you're asking for. Because if you tell a debt collector, I don't recognize this debt, they 100% have a right to send you a statement to show the debt. So there's just certain things you need to avoid. FDCPA is not for creditors. It is the Fair Debt Collection Practice Act. It covers collection agencies. The exception, again, is California. If you send a refusal to pay to a California creditor or a California consumer, your client's a California consumer, the CC violation I'm talking about covers the creditor as well, but only in California. I do not use power of attorneys, guys. I just don't. For me, it's not something I choose to do, want to do. And this process for me is so much more important because, again, you sending a power of attorney as a credit repair company to protect a consumer isn't scaring anybody. It's not. And I think it's an unneeded step, but that's just the way I work. Include basic identifying information. You got to write the account number, balance. I don't put all of the social in a debt collection letter. I only put the last 4 because I'm not going to give them any more ammunition to prove that the account is mine when I'm doing a validation letter. Make sure you send everything by certified mail or fax. You can do a fax. Save all correspondence you receive, because these documents could be actually the violation as well. One of my attorney's office has me send them all of the statements for my clients so they can review. And by the way, every single file in my office goes to legal review. I personally, at the end of the 6 months, do an audit where I scour all the data. I know what exactly I'm looking for, balances mismatched, creditors with collection agencies that carrying the same balance. So I actually audit every file. And if I have a violation or not, I send it to my attorney's office. I send them my audits showing exactly what I did find. And then I also send, even if I cannot find a violation, I send, and this goes for FCRA too. It's my whole 6-month process. All of my files go to legal review because I have a couple of attorneys that have given me my own personal associate, in a sense, to review my files, because they then find stuff that I cannot find or that I missed. So they have like employees that actually take my files and then they scour through them quickly to see if I've missed something, because I do miss stuff from time to time. So here's some good refusals to pay. I refuse to pay this debt. I'm not going to pay you for the debts you are trying to collect. I won't pay you. I will not be paying. And you are trying to collect from me. Those are examples of refusals to pay. Cease and desist. Do not contact me again. Please stop contacting me again. Please do not call me. You have to use those words to put the threat in place of, if you contact me, I will take this further. There are some CROs that do refusals to pay that don't have a backup attorney. So the cease and desist communication, if a collection agency sends back the response, they don't understand what to do with it because, well, they didn't have an attorney helping them understand this stuff. And that's really why I wanted to do this, because when I started the business, the attorney brokerage, I found so many credit repair companies that did not know what to do or weren't doing it the right way. And I wanted to help educate them, because I am a very big promoter of compliance and doing things the right way. When I tell you I had 2 state regulators show up at my door, I did, the state of Idaho and the state of Oregon. And the complaint that came, we knew it came from the competitor, because the state of Idaho sent me all of the documents he had turned in. And it was just a real jealousy thing. I got cleared, but guys, when the state regulator shows up at your door, you physically have to shut your doors. I was not able to even contact my clients who were my active regular clients that were in the middle of paying me. And they put me under the investigation. They opened all my files. They looked at my computer. They wanted to know a record of all of my clients because they investigated me, because they had to. It was a complaint, so they had to investigate me. And so you don't want the state regulators showing up on your door. And if you think that it's only a consumer that can complain about you, I see shady stuff between CROs all the time. All the time. I hear things that are being done to one another. It just really disgusts me. And I think I was having that conversation with my good friend John Deal today. Why is this industry so competitive with each other? You don't live in my state, and nor are you licensed in my state, so you better not be touching my clients, because if I find out that you are, or you've taken money from an Idaho resident or an Oregon resident, and you are not licensed in my state, you and I are going to have a polite conversation that I think that it would be in your best interest to refund my client's money. Because you have to be, and I don't care what anyone says, you have to be licensed in all of the states that require it. Some only require bond and registration. Some don't include anything other than, I think it's Colorado, where you just have to show your contract to become licensed. So you really should make sure that you know all of your state's requirements, because guess what, guys? It's all coming down. And I've been laughed at for the last 2 years. Every time I say this, it is coming down. They're going to start messing with us the way we've messed with consumers that we have no legal rights to mess with. So I just really feel.
That's exactly right, Shar. And that's another really good reason to join Occam right now. I'll give a shameless plug for Occam.
A little plug in. Hey, Matt Hearn, if you're on.
Yeah, give a shameless plug for Occam, because the Occam helps you do all of that. Make sure you're compliant, make sure you're licensed, make sure you're registered properly. All of that, we just hold your hand to do that. And it's so important. Like Shar, this is somebody who's actually been investigated by a regulator. Now she does things really up and up. She obeys the law. She is compliant. But is everyone? No, we're not all compliant necessarily. And if a regulator shows up at our door, what are we going to do? Right? She was able
correct.
She was able to get cleared. Not everybody can do that, but that's where we need to get everybody, is doing the same position that Shar is in right now. Get everybody to that position. So if a regulator does show up at your door, you can come out smelling like a rose, just like Shar did.
Well, thank you. Yes. So I think that, let's see.
Sorry, I just had to jump in on that. I probably made you.
No, don't apologize. So when is it a viable claim? So everything I do in my office, I told you I track. So I know the exact date the credit bureaus get, or excuse me, the collection or credit bureaus, depending on. I wait to make sure that it's past the 30 days, and then we pull an annual credit report after the first month. That's how I spot my first violation, is with the annual credit report at the end of my first month of working with my client. Where I catch my FCRA violations is at the 6th month. Because again, I sent the 2 letters to the credit bureaus, and I sent a letter to any creditor or collector, again, certified mail, that remains on the credit report at the 4th and 5th month. So some people think that the pulling of the annual credit report is intrusive and it takes too long and it's all just an inconvenience for the client. You came to me and you paid me, let me do my job for you. And part of my job is making you responsible to certain things that happen on your file. So I actually created a video of pulling annual credit report. And so I send that out to every one of my clients, and I'm like, hey, it's time to pull your annual credit report this month. And don't forget, we're going to be pulling at the 6th month mark. So don't feel like because I had it pulled at the 1st month that you don't have to pull it at the 6th month. And yeah, that's kind of just what I do on that. But the annual credit report is very important in this, and it takes 5 minutes, you guys. I will only pull the annual credit report if it's an elderly person who just has no technical skills and has no one to help them, or if you just cannot do it and you're like struggling and it's, and I'm going to tell you something else. I don't feel that anytime you send our phone call, because the phone call, the representatives at the credit bureau, when you're pulling the annual credit report, they tell you to go online and get the form, or they'll send you the form, and then you send that form back. It's a whole huge mess, and it half the time never works. And you click all 3 bureaus and they send you one. Or I have clients that I sent 4 certified mail month after month after month. It's only supposed to take 2 weeks to get an annual credit report in the mail. And he has deceased on his report. And it was found by the car dealership that he recently went and got. This credit repair thing and the violations that people don't realize, we're not just talking about identity theft. We're not talking about mixed social security numbers with different accounts on your credit report. I have a guy that just went through bankruptcy, and my bankruptcy attorney that I refer to in Idaho, they send me back clients. So I get them send me clients that don't need bankruptcy, need credit repair, but I do a post-bankruptcy review, and they send a lot of their clients to me, and I find things all the time, like balances that were never taken down to zero, and I send a letter out and catch the violation with that. So this whole pre-litigation, as I call it, for FDCPA and FCRA, it's a whole different world out there, you guys. I find original creditors with the collection agency that hold the same balance. So if I can't get that updated in a 35-day time frame, I send it to the attorney. You report my client deceased on their credit report and they're sitting in front of me, I send that to an attorney. Post-bankruptcy reviews, you guys, I have a $52,000 Mercedes that they will not update. We pulled all of the PACER records. It was supposed to be part of the bankruptcy. He gave it back. He did not keep it, so he didn't amend that part of it. I have another guy that went to a medical bill was $28,000. It was part of the bankruptcy, and the attorney in Boise actually called me to say, "Hey, Shar, this is what we've got going on. Can I send them to you?" Because they send me all their files, and then I can send them to my other attorney. And it's just like a big circle that we've created doing this. So it really is a lot of information, but if you take the time to learn it and do it the right way, it is so easy, you guys. My assistant knows that if it's a third month, she knows exactly what letters she's sending out. We do not do the click, send. I feel like a lot of CROs, and I'm not trying to be offensive to anyone, I feel like a lot of the CROs, they don't understand. They feel like they bought a software for $99 a month, and in 14 days, you too can be a credit expert. It doesn't work that way. I call it the click, submit, click, send, whatever. Click, you just are generating a letter because that's what the software told you to do this month. And so I just think that all the way around, every one of us needs to get smarter about the way we do things in our office, because it's not a joke anymore, you guys. It's just not. It's not a buy a software for $99 a month and you too can be a credit repair expert in 14 days.
So let's go ahead and open it up for questions, because I know I literally have a whole page of questions here for you. So I'm going to stop the share.
Perfect.
And just so I thank you so much. That is a lot of information to be given out. It was really good information. And before we end up, Shar too can share with you, maybe Shar just in the chat, put in your information so that, yeah, post your information if you can in the chat right now, Shar, so that if somebody wants to contact you, maybe for coaching or to buy your course or anything like that on this. This was really good training. I know that you barely just touched on it. So I had a couple questions for you, and then we'll open it up to the rest of you guys for questions too. Like you said in the beginning that you structure taking part of the settlement for your clients. That's how you get paid on that.
Uh-huh.
So how do you do that? What is the structure? Like what percentage do you take of the settlement? And do you just create a contract with them in the beginning to do that?
Yes, they know it coming in if there's a violation that I get a percentage in my office. I want to go and I'll talk to you about what my percentage is, but I have never had a client not be forthcoming and say, "Shar, I got my check, let me get you paid." People are excited that this is happening for them, that these accounts are getting deleted and the debt dissolved, and you then are getting money in your pocket. I used to take 10%. Then I went to 25%, and I actually take 50%. Now, if you have a $100,000 identity theft case, I'm not taking 50% of your money. We're going to negotiate something different because I'm not stingy. I use this money because I truly do help a lot of people in my community. Single mothers, families that want a home but can't afford it, I can give discounts, and that's the way I help people. So I take 50% right now. That's just on a standard E8 violation or CC violation, the refusals to pay and the failure to mark and dispute, and the communicating with my client. Okay. So yeah, and it all varies. And I want to real quick say this. I never quote anything about a settlement. I don't even know if you have a case. That's for the attorney to determine. And I don't know a value of a case. That's again for the court and the other attorney and for them to figure out. So I stay away from quoting pricing. But yes, it is part of my contract. It's absolutely part of my contract.
Okay. So in the beginning too, you said you send, the first thing you send is just a regular debt validation letter.
Yes.
So I do that now. Like I send debt validation letters to the third party creditors typically, and I do get a percentage of deletions from doing that. Now I've never done anything else but that. That's what I do. That's the extent of what I do.
Well, I'm going to teach you how to change that, okay?
Yeah,
I'm going to teach you personally how to change that because it's very easy. And if you're getting deletions, that's one part of the pie. But if you're getting the violations, that's the second part of the pie. And so you don't want to be leaving any money on the table.
I do get deletions for sure doing that, but I've never understood what violations were. So yeah, I want to learn that from you. I'm going to be getting with you one-on-one for that.
Perfect.
And then you said something about an inconvenience letter. I had a what is an inconvenience letter?
So that's what I happen to call it. It's my verbiage. It's part of, so I was only doing the debt validation part. And then more recently, I started listening to all of this stuff about if you also request that they only correspond with you via a certain method, that's what I call it. It's inconvenience verbiage. So I can catch them in 2 violations on 1 letter.
Okay. And then can you expound a little bit on the power of attorney and why you don't use it? You mentioned that you really don't use power of attorneys. I don't either. Some people, a lot of people do now use power of attorneys. And so tell me your thoughts behind on that, because I'm not, I would like to hear your thoughts on the power of attorney.
So I never used power of attorneys originally because I thought that it was an extra step and it didn't do any different. I'm not going to have them be afraid that you have a power of attorney and that's why they're going to delete an account. And I don't have attorneys that want to work with power of attorneys. It says that this was a credit repair company. They prefer to have the violation look like it came from the consumer disputing it.
Okay, so that's what I've always felt too. That's my same reasoning, as I don't want to notify the bureaus or the creditors or anybody that it's a credit repair company doing it to begin with. You know what I mean? Even if I have a power of attorney, I've always felt like that was a no-go for me. I don't want them to track it. They can track all that. They can track every single letter you ever sent. So if they can get you for anything, they want to get you on any time they feel like getting you. Because
and
they know
that
exactly who sent it.
Yeah, and that also creates a lot of those stall letters. Why do you think the credit bureaus know that the consumer is working with a third party? Because they're getting the power of attorney. And although there's no law on it, I think that there's a rule on it with the FTC. I've never investigated or looked into it, but I don't have attorneys that will want to work with a power of attorney. They just don't.
Okay, so that's interesting to me too. Okay, so I'll open it up to everybody else for questions. I know I had a whole bunch I had written down as we went. So go ahead. Who else has questions for Shar?
I put my email, my phone number, and you can contact me on Facebook Messenger with my name right in the chat. So if anybody doesn't want to come forth because of an embarrassment or they think their question's not worthy, you can always behind the scenes send me your questions. At some point, if you're asking questions and spending an hour or 2 of my time on a weekly basis, I will have to start the mentoring program with you. Everything I did, like I said, in my course was crafted and put together with all of my knowledge, and it's pretty detailed. So if someone wants to talk about that as well, other than that, I'm just available for general questions on a regular basis.
Yeah, I really appreciate you taking your time, Shar, tonight to come in and teach, because not everybody does that and give all this great information, you know, for free.
Because all of the misinformation out there is too powerful not to pay attention to, you guys. And so I just would really I want to express to you guys how important it is, if you are newer to this industry or if you have questions, that you get with a viable resource and not just someone off the Facebook group that you've known for a week. Okay.
Yeah, that's good advice for sure. Make sure somebody has some experience in this industry. They know what they're doing. They've been doing this for a while. Like Shar has 30 years experience. I have 20 years experience. We've been doing this for a long, long time. We have seen many iterations of how credit repair is done in those years because it changes all the time. How we do credit repair.
Yes.
I do credit repair very differently than I did credit repair in 2004. Okay, today.
Absolutely.
Yeah.
Absolutely.
And it changes all the time. In fact, I do credit repair very differently right now than I did 4 years ago. Okay.
Correct.
Always changing. So you always have to be staying up on it. So it is important to attend classes like these, especially when they're being offered to you for free with people that actually have been doing it years and years. So we're just happy you guys took advantage. I'm shocked that when we offer these free classes and all this free information that 100 or 200 people don't show up. I've never been able to figure out why that is.
I've been teaching pre-litigation credit repair for 5 years now, but it surprises me that when I was teaching it for free and I was hosting classes and I was offering all of this information at no charge to anyone, my passion is credit repair. I happen to make a living on it, but my passion is credit repair. And if I could do it for free, I absolutely would. I appreciate your time and thank you for everyone who attended.
All right. Thanks, everybody.
Okay. Bye.